Probate is the process of having a last will and testament offered to the surrogate's court in the county where somebody dies and validated by that court as a valid last will and testament. The process of probate can be rather straightforward if there is no one who would object to the will. A would-be objectant to a will would typically include a child who is disinherited by the will. The process of probate not only includes offering the will to the court to pass upon its validity, but in doing so, the court will set a hearing date whereby any child who is disinherited and is not expressly consented to the probate of the will has an opportunity to show up and inform the court that they wish to contest the will. If a will is contested, it becomes a lengthy process and proceeds to litigation. If nobody objects to the will, the probate process typically takes anywhere from 2 to 3 months, and once the court has passed on the validity of the will and found the will to be valid, the court will appoint the executor, who is named in the will, as the executor of the estate, and that person will be tasked with collecting the deceased person's assets, paying the deceased person's debts, and ultimately making distributions to the beneficiaries of the last will and testament. The administration process is very similar to the probate process, but the administration process is the process whereby somebody informs the court that somebody has passed away without a last will and testament and asks the court to appoint them as the administrator for the estate. The administrator's role is very similar to that of an executor. However, as mentioned before, administration is necessary when there is no last will and testament. When there is no last will and testament, the law prescribes who can serve as administrator for a deceased person's estate. If there is a surviving spouse, the surviving spouse has priority and will be appointed by the court as the administrator if they are not otherwise found to not qualify. If a person passes away without a surviving spouse, the children are the ones who have priority to serve as administrator. So when somebody passes away without a last will and testament, it's important for the family to discuss who the administrator should be and who's best suited to act as administrator for the estate. Much like the probate process, if there is no dispute as to who the administrator should be, a petition is filed with the court asking the court to appoint an administrator, and if all parties consent, the court will appoint an administrator for the estate, typically within 2 to 3 months. Much like the executor, the administrator is also tasked with collecting a deceased person's assets, paying the deceased person's debts, and ultimately distributing the estate to the people who would take under the laws of intestacy. The laws of intestacy are laws which provide who is to receive a deceased person's estate in the absence of a will. These are typically surviving spouses or children, but the law also provides for other distributees when there is no surviving spouse or children. Much like with a probate, the administration proceeding can also be contested. The contest that can arise with an administration proceeding is if family members cannot agree who is best suited to serve as administrator for the estate, and perhaps 2 children are arguing that they are better suited than the other to be the administrator. As with the probate proceeding, before an administrator is appointed, the court will have a hearing date, at which point any person who would have priority to be the administrator will be invited to show up to the court hearing and either state that they consent to the proposed administrator or wish to dispute that person. If there is a dispute, the matter will proceed to litigation, which will be discussed in another segment. If there is no dispute, the court will appoint an administrator in 2 to 3 weeks, and they will begin the process of administering the estate.